Good morning, everyone. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Royal Commission's legislation amendment, Protections for Providing Information Bill 2026. I want to begin by making it clear that these are public proceedings, and although the committee may agree to request to have evidence heard in camera, or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. It is also contempt to give false or misleading evidence. As Chair, I'll ensure proceedings are conducted in an orderly, respectful and courteous way, and I remind committee members of their obligations under the Behaviour Code for Australian Parliamentarians and resolutions of both houses to treat witnesses with dignity, courtesy, fairness and respect. In accordance with the committee's resolutions of 26th of August last year, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will also be published on the website. On that note, I'd like to now welcome this morning to Chris Taylor of the Australian Strategic Policy Institute to give evidence at this public hearing today. For the Hansard record, could I ask that you please state your full name, the capacity in which you appear before the committee?
Chris Taylor. I'm the head of the Statecraft and Intelligence Policy Centre, the Australian Strategic Policy Institute.
Thank you, Mr. Taylor. Although the committee does not require you to give evidence under oath, I should advise that this is a legal proceeding of Parliament and therefore has the same standings as proceedings of their respective houses. Giving a false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Did you happen to have an opening statement this morning, Chris?
Oh, yes.
I'll hand over to you.
Chair, thank you for the invitation to appear today in relation to the Royal Commission's legislation amendment, Protections for Providing Information Bill. At the outset, I should note that my evidence today is given as an individual. While I do so in my professional capacity as head of the Statecraft and Intelligence Policy Centre at ASPI, it's important to clarify that ASPI does not have institutional positions including on this bill. I also note that my remarks and subsequent answers to your questions may be constrained by the limited opportunity that I've had to engage with the bill since its introduction into the Parliament at the beginning of the week, and other documents such as the arrangements that have been made. In saying that, I register my strong support for the establishment of the Royal Commission to inquire into the 14 December 2025 terrorist atrocity at Bondi. A Royal Commission was the only appropriate response to the worst terrorist attack yet carried out on Australian soil, against a background of sustained political violence, extremism and anti-Semitism. It's only appropriate too that the Richardson Review's work be folded into the Royal Commission's proceedings. It's my hope that the input from that review will serve as a starting point for the Royal Commission's consideration of the matters captured in term of reference C relating to intelligence and security, that is C6 through C9, and not an end point. That's why it's important that the Royal Commission is able to question and take evidence from intelligence community witnesses, both representatives of agencies, but also those who might have additional knowledge of the matters in question, including those volunteering that information. Indeed, passage of this bill will likely send a positive signal to those who might have information to volunteer. My strong support for Australia's current secrecy provisions leads me to support the bill's requirement that information is imparted through arrangement made between the Royal Commission and the Commonwealth. It's my belief that it was not the intention of the Parliament in having previously passed those secrecy protections for them to inadvertently hamper the work of Royal Commissions, given that they are the highest form of judicial inquiry in the country and commissioned by the Executive. Ideally, testimony and evidence given to a Royal Commission should be made publicly where possible, but the reality of the national security classified and other sensitive information that is the subject of this bill means that it may need to be provided in camera. This reflects the intensity and potential consequences of Australia's intelligence contest with adversaries and other bad actors. It also reflects undertakings given to intelligence partners when exchanging intelligence information. In this regard, I do note that Article 42C of the Intelligence Information Protection Arrangement seems to require the written approval of a head of an intelligence entity for any disclosure to the Royal Commission of foreign government information, as distinct from other forms of intelligence information that might be volunteered. I do note one misgiving, which first arose in reading the amendments to Division 122 in Part 5.6 of the Criminal Code, establishing a defence to an offence under that division where a person communicates or deals with information for the primary purpose of providing it to a Royal Commission and the person has a reasonable belief that the information is relevant to the inquiry. My concern on first reading was not with the intent of the amendment, but with potentially inadvertent consequences for security. I understand now from evidence given by the Attorney-General's Department yesterday that this particular amendment provides a defence only in relation to the general secrecy offences and not to the other offences specific to particular legislation concerning the intelligence agencies. But despite that clarification and the broader discussion in yesterday's hearing, I still harbour concerns about the potential for persons with privileged access to sensitive information to take actions such as the removal, copying, unofficial storage and communication of that information in ways that might prove to be insecure, exposing that sensitive information to loss or acquisition by adversaries. I am well assured by yesterday's statements from both AGD and the Office of the Royal Commission about how a volunteer's verbal testimony can be securely imparted. I'm less assured about how, just as a practical matter, related documents and artefacts are being treated, including the generation and handling of classified notes made in support of verbal testimony. It seems to me also that there's a certain responsibility on the part of agencies in this regard to provide suitably secure and protected means for any such action by staff members seeking to exercise this option. For example, by classified email connectivity that keeps classified material relevant to the Royal Commission within a classified system, and to ensure all staff are confident that use of those means for this purpose will be protected and respected, including from administrative actions. This situation isn't wholly alien to agencies. After all, there are existing requirements to provide staff with similarly secure means for handling and communication of classified material, coupled with protection of the staff making such disclosures in relation to bodies like the Inspector General of Intelligence and Security and even internal ombudsmen within agencies. Further clarifying this issue, i.e. through recommendation of the committee, could avoid an unwelcome gap in security arising between origin inside an agency and information's receipt and secure storage by the Royal Commission. It could also avoid the more general undermining of agency security practices and culture. My thanks again for this opportunity.
Am I able to take that now? Brilliant. And obviously it'll be distributed, but that way we can also look at it.
And just before you do that, I'll just ask, you're happy for us to table a copy of that? Thank you.
Brilliant. Mr Taylor, that was an absolutely outstanding opening statement, and we do very much appreciate in such short time you coming to the committee. Just in relation to what you've just said about the storage, etc., and the inadvertent disclosure of information, can I ask you, what would exactly the recommendation look like?
I apologise. I'm perhaps not in a position to provide such exact advice to the committee. I think some signal from the committee to agencies I think would be appropriate. I personally don't doubt the good faith of agencies in dealing with this matter. And again, I'm assured by the testimony that was given yesterday by the Office of the Royal Commission, for example, about their collaborative relationship, the fact that they have been able to enter into these arrangements. I think those are all very good signs. I think that it's just important for agencies, not only at the leadership level, but for example, at the level of those whose responsibility is and duties it is to carry out security actions, that that all of the staff of agencies are confident that the systems and the arrangements that have been made inside of agencies in order for people to be able to provide evidence to the Royal Commission achieves two ends. It achieves the end of security, because again, per my opening statement, my concern is in some way a gap being opened up that occasions information essentially leaving classified systems, classified premises, and in the course of being given over to the Royal Commission. I think that's, again, much easier to do with verbal testimony. I think that's entirely possible that a person can make themselves known to the Royal Commission, that they can they can engage in all of the practical arrangements that the Royal Commission talked about yesterday in terms of private interviews, in subsequent hearings and so forth. For information that's contained in somebody's head, that's really, really easy to do. I suspect, however, that even in those circumstances, people will be either reliant on or wishing to be supported by some form of written evidence, whether that's particular artefacts or documents or even just notes that they might have taken. And that's I suppose that's, of all the things, that's my one concern, is that by potentially opening up gap, and again, I think entirely inadvertently, and these are merely practical matters, but it worries me that if there's some sense in which people don't fully trust what's made available to them, or indeed, and I don't think this is going to be the case, but in those systems aren't available to them, that they will, in a sense, be circumventing existing security arrangements. And an attendant element of that is, in a sense, given how important security culture and security practices are within these organisations, anything that, again, inadvertently undermines that by essentially creating some perverse incentive to do something unwise or informal, I think should be avoided at all costs.
If I go to the key purposes of the bill, so to facilitate the provision of intelligence or operationally sensitive information to a Royal Commission, it then amends the Royal Commission Act to provide immunity from Commonwealth secrecy offences where a person provides, and these are defined, intelligence or operationally sensitive information to a Royal Commission as prescribed, etc. Clarify that it is not a reasonable excuse to fail to provide the intelligence or operationally sensitive information where required by a Royal Commission because it would contravene a secrecy provision. Is it your assessment that this bill adequately protects current and former intelligence officials who may want to proactively disclose information to the Royal Commission?
That is my assessment, insofar as I do think that, again, buttressed by the testimony that was given yesterday about how it's intended for this to function,
yes,
that it will achieve that end. I am just worried about gaps opening up in the seams between how that actually occurs in a practical fashion. I think the best of intent is there. I think that this is a very appropriate legislative response. In a way, it's again, it is not a surprise. There are a multitude of legislative priorities for all governments. We have had the recommendations of the Royal Commission into Defence and Veteran Suicides. I think this is, in a way, this is a function, and again, this was referenced yesterday, that the Royal Commissions that we have had, essentially in the last 4 decades, have not tended to be in relation to national security. We've had a variety of means of doing what previously, for example, the First and Second Hope Royal Commissions did, through mechanisms like the independent intelligence reviews and so forth. In a sense, in a certain way, the system has matured since then. We haven't had, we had, for example, the Commission of Inquiry, Samuel's Cod Commission of Inquiry in the mid-1990s into ASIS, but it's been issues of national security material and classification has been at the margin of the work of Royal Commissions. So I do think that this is appropriate in relation to the current Royal Commission, and indeed it's a sound move in relation to future Royal Commissions.
Okay. Just in terms of the second part of what the bill does, the bill also amends the Criminal Code.
Yep.
Okay, to make it a defence to an offence under under Division 122 that deals with secrecy information, where a person communicates or deals with information for the primary purpose of providing it to the Royal Commission and they had the reasonable belief, etc. That will become a permanent change to the architecture of our security laws. Can I get your views on that as well, and whether or not that is adequate? Again,
I see that as a sound move. I suppose my concern there is to make sure that, again, there's not missed signals to people. For example, and again, people may be a lot smarter than I am, but in my first reading of the bill yesterday,
yes,
my first reading of the bill yesterday, in looking at the changes to the Criminal Code, I was like, oh, that opens up this potential for, shall we say, kind of informal, self-directed action in relation to disclosure. The fact that it took the testimony of government agency representatives yesterday to correct my understanding.
And can I ask you on that, just so we get this on the record, because this is very important, take me through why the evidence given yesterday corrected your understanding.
Indeed, because it pointed out that the secrecy provisions that apply in acts like the Intelligence Services Act, the ASIO Act, the ONI Act will continue to apply, that this defence does not relate to those offences, it relates to the general secrecy offences in the Criminal Code.
Can I ask, in terms of intelligence officials.
Yeah.
Okay. Are they adequately protected in this?
I have to say, in a way, that's outside the scope of certainly my
that-
expertise
yep.
and again, my
Is that outside the
expedited
scope
reading.
of the bill? Because the bill specifically does deal with intelligence and secrecy.
I'd hesitate to give an answer because I don't think I'm expert enough to provide a useful answer for you in that circumstance.
Just going to, and this is something we explored yesterday, and I didn't receive adequate information on it, and we will be putting questions on notice to the relevant agencies, but it goes to the point that you first raised. What are the sorts of resources and messaging internal within the agencies that you'd expect to see to ensure the intelligent workforce in the first instance knows their rights to undertake voluntary disclosure?
Yeah, again, I would expect that there is a communication from the leadership of agencies, important that would come from the very top of those agencies to provide that degree of assurance and go to practical advice about how to do these things securely, how to make contact with the Royal Commission, how the arrangements are intended to work so that people don't fall foul of the arrangements as they exist. And again, that will be this is a 20-page document, providing a suitably plain version of that that's understood by the entirety of a workforce, given there's a great diversity in the roles and people engaged in this work, making sure that, and again, this is not wholly alien to agencies. Agencies are used to communicating internally about all manner of things, including about security. So they are well versed in how to do this. I think it would just be, and again, I'm not saying this because I think that they have not done this or they don't intend to do this, but I would expect that is the way.
Well, given the nature of what we're actually looking at in the bill.
Yeah. That they would be communicating that to their staff, that it would be plain, it would be crafted in order and indeed underpinned by a genuineness in saying that we will make available these means to securely allow for connection with the Royal Commission, the provision of any documents or artefacts in that way, and that it won't be subject to some form of administrative action, or
Correct.
It won't be in some way monitored in such a way as to lead to a loss of that trust.
And were you satisfied?
And that's a delicate balancing act.
No. And were you satisfied yesterday? Because this was the crux of a lot of the questions that we looked at yesterday. There's one thing to be compelled to do something by a Royal Commission. You accept that you have to do that. At this point in time, the legislative bar are the secrecy provisions. Yep. We will lift those and put in place the immunities as is appropriate. But are you satisfied then? And perhaps I put it as the question in relation to those who are not compelled, to the voluntary disclosures. Do you have a view on what actual systems and processes should be in place for someone to make voluntary disclosures? For example, should there be things like dedicated secure networks or messaging systems so officials can communicate directly with the Royal Commission without fear of colleagues being aware of those communications? Because I think this is, other than the Hope Royal Commission, this is, as you've already articulated, probably the first time in decades that we are specifically looking into the intelligence agencies and their role in what occurred.
Yeah, it's certainly in this kind of form of a Royal Commission.
Yes.
I'm not quite old enough to be, to have been there for the flood inquiry, but given the flood inquiry's terms of reference related to a number of particular intelligence incidents, I would expect that at the time there would have been some means for individual officers in agencies to be able to in a sense, volunteer information to Mr. Flood. I would, in my view, it's not a question necessarily of new or different systems.
Yep.
It's using the existing systems.
Yep.
Because that means, this is my central concern, is to make sure that classified information doesn't leave classified systems. And again, I personally, I see the provision of information to the Royal Commission via part of the existing classified systems, so systems that are appropriate to the level of the material, the classification level of the material that's being provided, That seems to me to be the most sensible and secure way of doing these things, not having alternative systems or anything like that. But that does mean that those systems are necessarily part of the existing arrangements for security and monitoring, etc. So it's then a question of ensuring through actions, through culture and so forth, that there is assurance to staff that it won't be in some way, that they will be allowed to make those
Correct.
representations in a protected way.
And this was, as I said, probably the crux of the questions yesterday were not so much in relation to you're compelled. It's given the nature of what occurred, it is those people in those agencies potentially being in excess of classified information which they want to provide, and ensuring that, as you said, the adequate protections are in place for them, not just to provide the information, but also so there are no repercussions in relation to their employment and themselves personally.
And I think agencies and agency leaderships have an interest in that, because if for some reason, and again, I am not suggesting in any way, shape or form that this might be the case,
No.
but if there was some level of distrust, then people would use alternative means, and that is what
where the problem
that
is.
is what I am endeavouring to make sure it does not occur, is that there is some informality or unofficial, or in a sense the transgression of existing security practices, because there's some lesser level of confidence in the way that that contact with the Royal Commission will be treated.
Can I just put to you a point that's raised in the submission that we've agreed to publish this morning? Scope of application. This is what this particular submitter says, but I'd just like to get your views on it. The most significant shortcoming of the bill is that in providing legal protection for the provision of information to our Royal Commission, it only applies to intelligence information or operationally sensitive information. Material that is not of that nature, but which may nevertheless be of relevance to our Royal Commission and is otherwise covered by secrecy obligations, could not be voluntarily shared with the Commission without the disclosure, in this case the person's referred to them as the whistleblower, risking criminal liability. Now, I'm not saying that statement's correct, but I'm asking for your views on it.
Yeah, I must say I'm not sure. I would need to, in a sense, work out in my own mind. Again, I'm a very practical person. I am not a lawyer. I would be trying to understand what particular category of information that we're talking about that doesn't fall into intelligence information or operationally sensitive information.
Because if it doesn't, then it is not covered by this bill, but it may not need to be covered.
And while also noting the, again, a testimony given yesterday, I think it was by AGD, about the other laws that apply in relation to cooperation and standing in the way of cooperation with the Royal Commission, as well as simple workplace laws, etc., in relation to people's activities.
I'm just having a look to ensure that, just in terms of a more holistic comment on the bill, these provisions obviously, I use the term turn on and turn off because that's the easiest way to sort of get people to understand publicly what the legislation and the effect of it will be. They turn on once the Royal Commission is A, tick letters patent, but B, the arrangements must be in place. They turn off when the Royal Commission comes to a formal close. They can then only be turned on again, other than the Criminal Code Amendment, which is now a permanent change to the national security architecture, but really merely consistency with courts and tribunals. We're not actually creating something new here. If a Royal Commission is then prescribed by regulation and then you have the arrangements published, can I get your comments on the adequacy of that?
See, I think those arrangements are adequate.
Yes.
Those changes to the law.
Yep.
Again, I think it creates a requirement for agencies to henceforth be very clear in their communications to their staff about what is in and out of scope when it comes to exactly that turn off, turn on element, because I would be concerned, that in a sense they'll now need, and not unreasonably need, to incorporate into their more general advice to staff about secrecy, about security, about disclosure, the kinds of things that they provide to staff in relation about IGAS, about the NAC. They'll need to incorporate in very clear language what these changes are in relation to Royal Commissions. For one, the fact that we will now have had a Royal Commission dealing with a national security matter will create a revived sense that Royal Commissions are things that deal with national security classified material, including intelligence material. So it will need to be clear in subsequent security advice to staff about exactly what you've mentioned. That is that the provision of let's say intelligence information occurs in these particular circumstances, where a Royal Commission has been called, where it has been prescribed for the purpose of legislation, and where an arrangement has been struck between the agency or agencies and that Royal Commission, and that it applies only in those circumstances, lest anyone think that due to necessarily the publicity associated with this bill, associated with this Royal Commission, that they get a misimpression about the circumstances in which information can be provided, including this idea, as it was articulated yesterday, about anticipation of the Royal Commission.
Yes, correct. Because this was anticipated all through December. Yeah. Correct, but wasn't called until... Flowing on from that then, there is an interim reporting date for the Royal Commission set by the government of the 30th of April 2026. If this bill goes through, obviously this comes into play. They will start to receive the intelligence information that is currently being withheld because of the secrecy provisions. Would you therefore say it would be appropriate that post the 30th of April report from the Commission that the PJCIS undertake another review to ensure that the bill, and which would be coming out, is operating as intended, to ensure that there are no unintended consequences, as you have articulated?
I think that's a good idea.
Yes, exactly. So do I. No, absolutely. Because once this evidence is in, whether or not the government thinks it's a good idea is another thing altogether. But certainly, thank you very much for that, because I would say it's also a good idea, because then we'll actually have the proof in the pudding in relation to disclosures.
And returning to my opening statement, I am very much of the view that the Richardson Review, that is that preliminary work that was fundamentally about understanding from the first sense what agencies understood, and what agencies understood had happened, should be the start point for the Royal Commission's engagement with the intelligence and security issues involved in the 14th of December. It should not be the end point, precisely because it may well be that there are further questions to be asked of agency representatives, further testimony to be given by people who are volunteering evidence. So again, I don't know what the intentions are in this regard of the Royal Commission, but I would hope that it is not a case that on the 30th of April we cease talking about and the Royal Commission ceases considering the intelligence and security dimensions of this matter.
Do you think the bill will provide adequate protections so that Australians can learn the full story about how our counter-terrorism policies were being handled leading up to Bondi?
Again, I think that the changes that are being made provide the best opportunity for the Royal Commission to do its work.
And what are the main elements of the Royal Commission's work? And again, this goes to the crux of the questions yesterday, to ensure that there are adequate protections for voluntary disclosure. Where you anticipate that it will be most important for voluntary disclosures to take place?
When thinking about the intelligence issues that are at play, there's obviously a question of decisions made regarding past investigations, past cases and so forth. And indeed, and this is why I hope the Royal Commission is able to deal with these issues, it does raise a number of interesting matters with regard to how adequate legacy intelligence models are for dealing with things like, I mean, as I might term them, a kind of kitchen table conspiracy. So a lot of our ways of thinking about security intelligence are predicated on the idea of organised conspiracy, about people engaging with each other via communications or in person. That was the nature of a lot of the counter-terrorism prosecutions of the 2000s. They were conspiracies engaged in by people who otherwise had some connection but were not living together. They were not, they were not engaging in a conspiracy around the proverbial kitchen table. So there's a whole range of important questions, not only about what happened and decisions that were made, but actually about what the implications are for the way that the intelligence and security should work in Australia, with particular relation to this evolving model of terrorist threat.
This is a general question more than anything, given your background. Do you think foreign intelligence or insights from Five Eyes partners would be important for the Royal Commission to hear from?
I do. Yeah. I think that's an important part of the intelligence picture.
I think also, Senator Dunham, do you have any further questions?
Look, just back to a couple of the points, Mr. Taylor, you were making. In your opening statement there, you mentioned, and you've talked a couple of times in response to Senator Cash's questions about that handling of information and how it's guidance from agencies that's important for staff and individuals, identified personnel in the legislation to be provided on how to handle this stuff. Are you saying that is something that can be dealt with internally? There's nothing we should do legislatively to instruct guidance on how to handle? Because as you say, it'd be great to have it in your head, but you do need an aid memoir to provide such information in.
I do. It's not struck me as to how you might be able to resolve that matter through legislation. I think this gives a sound legislative basis, but it will then require actions by agencies to make that a practical reality, and one that's more secure than a free-for-all.
And we haven't had a chance, for obvious practical reasons, to interact with agencies about the legislation, but is it the kind of thing you would expect the government should indicate to agencies is something that should be put in place, just to give assurance to...
I would have thought so, yes.
Yeah. Maybe it's something that the committee could make mention of.
Absolutely.
Yes. Yeah. No, that was the only thing I wanted to pursue.
Can I just ask then, is there anything else that you'd just like to tell us in terms of the bill? No, but meaning, have we missed it? Is there other information you'd like to provide to us in the context of the Royal Commission, the bill, etc.?
No, I endeavoured to encapsulate that in my opening statement. As I said, I necessarily probably have more questions for you than answers.
No, I have to say, no, this has been incredibly helpful in terms of, as you say, and I like what you said in terms of your opening comment. It was it was a fundamentally different intelligence environment when the legislation was first put in place. So it may not have anticipated that this would need to occur. And on that basis, this is really one of the first Royal Commissions that has absolutely encapsulated and looking at the role of our intelligence agencies. Yep. So it's now appropriate to actually look at what we can do. I mean, the Hope Royal Commission, it did what it did. The Veterans Royal Commission had to end up doing a workaround. Not an ideal situation, however. So this does obviously provide us with the legislative response. And in any event, it comes out of the 2023 secrecy review. I'm surprised it's 2026 and we're doing this now. I've got here point 8 in the Human Rights Law Centre letter gives an example. I don't actually have the Human Rights Law Centre letter at hand. Give me 2 seconds. I'm sure my office is listening to what I'm currently saying. Exactly. It's like, I actually, just hold on for one moment. I do have... Okay, hold on for 2 seconds. Right, okay, I do have it now. So, point 8 in the Human Rights Law Centre gives an example as an illustration of a practical way there could be an issue, okay, as per your evidence earlier. It is a hypothetical example, but it's taken directly from. An employee in the Department of Education is aware of information of relevance to the Royal Commission's inquiry into security arrangements for the Jewish community in relation to, say, childcare. There are secrecy offences in federal laws relating to childcare. They may be applicable to the relevant information. Say the Department of Education employee voluntarily provides the information to the Royal Commission, they may be in breach of those specific secrecy offences. Moreover, they may be prima facie liable under the Criminal Code, required to rely on the new proposed defence and the burden of proof in establishing that defence would fall on them. It is not clear why an intelligent agent should have the benefit of this new regime, but the Department of Education employee should not, when both are seeking to do the same thing in the public interest, provide relevant information to the Royal Commission to assist its inquiries. And that is actually from the submission that we're tabling this morning. That is one of the concerns of this submitter. This deals with a certain class of person, but there are other departments who may also have access to, but they don't necessarily, well, they don't get this protection.
I don't think I'm able to answer your question in any kind of useful way, given my...
No, that's okay.
My mind has not turned to the application of these things to persons who, for example, who would not be normally in receipt of national security classified.
That's fine, and we can put that to the department because we didn't have the benefit of the submission last night. That's actually given me almost everything that I need, Mr. Taylor, and I very much do appreciate you taking the time at such short notice to come in this morning. I mean, we also only got the arrangements as we were walking in last night, which was not ideal, but the arrangements have been published, obviously, which certainly does assist us.
I would note there, not being churlish or anything, but I only knew about the arrangement from the testimony that was given last night.
Right.
And endeavouring to find it on the Royal Commission's website last night.
Was not easy?
No, I had to search for it on the Royal Commission. Now,
Okay,
I'm sure that might be. I'm sure that might be being.
But we will also. That's something that we will.
I'm sure that's in there.
Everything that is done needs to be made as simple as possible, given the nature of the Royal Commission and the fact that we actually want people coming forward and telling the Royal Commission what they know. Senator Ciccone, do you have any questions?
Well, I'll just take the call back as the chair. Thank you, Senator Cash, for that.
I'm sorry to you, exactly. Sorry.
Are there any other questions the colleagues have?
Chair, thank you.
All right. Thank you. Thank you very much, Mr. Taylor. Chris Taylor, just to be clear, for your time this morning. Being no other witnesses for the remainder of our hearing today, can I declare this public hearing now closed?